Okay, good morning and welcome to the 10th Court of Appeals sitting in Waco, Texas on October 27, 2021. This is oral argument session. We have one case on the docket. It is Bailey versus Hillcrest, and I'll ask for announcements in a moment. Please check your cell phones, as will I, as I make this announcement, to make sure they're in the off or silent position. And Nita, if you will confirm when you get to the office that the live stream is functioning. Okay. And just as sure as I don't do this, it will happen to me like it happened to Tom Phillips once, that he will get not one but two phone calls during the argument. And that was after he had preached to everyone to turn them off. So we do allow counsel to move about the courtroom during oral arguments. Please do so respectfully if that's necessary. With the one argument, I doubt that we will need that break afterwards. After y'all case is submitted, we do talk about y'all after you leave. So, you know, feel free to depart when finished. If there are any exhibits that we need to talk about that y'all have brought, I need to know that in your announcement to make sure the other side has seen them. There's no objection. And if the attorney that is going to make the argument will give me their name when they announce. If you're going to split it time, I need to know that. Obviously, you're not. If y'all choose to split time, I don't track the time between the persons arguing. I leave that solely to you and your ride home because invariably the first speaker takes up more time than the agreed allotment. So calling the case of Bailey versus Baptist Medical Center. Can I hear from the appellate?
Randall Kaufman, Hoosier, Grant Hoosier.
Are you both going to be arguing, Mr. Kaufman?
No, Your Honor.
Okay. And for the appellate?
Your Honor, Laura O'Toole for Hillcrest Baptist Medical Center, Hillcrest Baptist Medical Center, DBA, Baylor Scott and White Health, and Scott Marshall.
Okay. Thank you, counsel. To my left is Steve Smith. He joins us as his first oral arguments, and he started in took the oath on September 1st of this year, and comes to us with
almost 23
of trial court experience. So he's heard about probably, I estimated at about 23,000 arguments at least. It's just that this is his first oral appellate argument. Matt Johnson to my right joined us in January. He has probably heard about the same because his docket had lots of criminal cases in it. And so for some reason, they seem to have a lot more argument in those cases and status conferences and everything. But he's already been here for a number of oral arguments. And so we're glad to have this wealth of trial court experience with us on the bench today and going forward. We believe this to be the makeup of the court for years to come. And absent something horrific, we look forward to this panel being the panel of the Waco Court of Appeals. With that, the appellant can proceed. The time is 20, 20, and 5 rebuttal. And we will adjust that on the fly if needed. And you may proceed when ready, sir.
Thank you, Your Honor. Of course, Monica Vaughn, who's no longer with our firm, handled this case from in its totality, the trial court, all the way through filing this appeal. We've tried to get her to come and argue, but she just says she's too busy. She can't come argue. So I'm going to do my best with her briefs and reading what's in the file. And underlying facts are that on March 31, 2014, Mr. Williams went to Hillcrest Baptist Medical Center to see a urologist with Hillcrest Urology. Hillcrest Urology is a medical group that specifically holds itself out as being a part of Hillcrest Baptist Medical Center and Scott and White Healthcare. He went in to have a cystoscopy, and apparently it was a very painful procedure for him. And after he was done, he was very lightheaded. He told the nurse that he was lightheaded and he had to go to the bathroom. So the nurse instructed him to go to the bathroom. He had no assistance. He just went on his own. And while he was in the bathroom, he fainted and hit his head and had a head injury and a cervical strain. Afterwards, he complained to Hillcrest Baptist Medical Center. An investigation was conducted, and the letter describing that investigation and given the conclusion was signed by a Janice Randley, who's the patient relations for Baylor Scott and White Health. And that letter also expressed the desire or a hope that the investigation would lead to the provision of better care at Hillcrest Baptist Medical Center. Now, a little bit less than 2 years later, Ms. Vaughn filed suit on March 1, 2016. As we could do then, she served discovery with the petition. The defendants asked for an extension, and she graciously granted them an extension to answer the discovery. When they did, they came back and told her she had sued the wrong party. And part of what she was asking for, she said, okay, go ahead and answer the discovery, and then please provide me the proof as to who the correct party is. As the case went on, a scheduling order was agreed to between Ms. Vaughn and the other counsel. Unfortunately, according to Ms. Vaughn, when the scheduling order was entered, she was not served with the entry of the scheduling order. And as a result, the deadlines were not entered on her calendar. And one of those deadlines was a deadline to designate her expert. And because of that, her expert was not designated timely.
I do have a question here. You mentioned you filed suit. Did the plaintiff ever file suit against Scott and White Memorial Hospital doing business as Hillcrest Urology Clinic?
Not that I can tell.
Well, one further question. You're here appealing the trial court's grant of a summary judgment. And the record before us includes the defendant's no evidence of traditional motions for summary judgment. And the only entity asking for that relief is Scott and White Memorial Hospital doing business as Hillcrest Urology Clinic. In the introductory paragraph and in the conclusion paragraph, that's the only entity asking for that relief. How do we wind up here with the grant of a summary judgment releasing all defendants?
Well, as I understand it, the other defendants were arguing they were the incorrect entities. And so they weren't liable because they just were not the correct entities. And she should have sued this other entity.
There was a motion filed that was the defendant's motion for leave to correct the names of defendants. Again, as Justice Johnson alluded to, the record before us does not show that that motion was ever ruled on. Is there any indication in what you've seen going through this record that that motion was ever ruled on?
I don't know. I don't remember seeing anything about that motion being ruled upon. No.
How are we to address an appeal when the motion for summary judgment was by an entity that you had not sued?
I don't know. All I know is that one of Ms. Vaughn's complaints is that she was not allowed to amend the petition to add the correct defendant.
Was there a deadline in the agreed scheduling order to add parties?
You know, I don't know. I don't remember. I don't remember what it said. I would think so, but I don't remember.
My review of the motion for summary judgment. Was there relief requested in the motion for summary judgment because and evidence included saying that the other entities were the wrong entities?
That's my understanding, that the motion for summary judgment was based on suing the wrong entity.
But you had sued, I guess you'd say, putatively 2 or 3 defendants, but not Hillcrest Memorial Hospital as doing business as the urology clinic.
Right. And Ms. Vaughn's argument is, one is, on a traditional motion for summary judgment, if the defendant has to prove who the correct entity is, and then that was never done, that there wasn't actual proof that this is the correct entity. The other argument is that, at least as we were talking about the statute of limitations, is that even if you have a misidentification and you sue the wrong entity, if the correct entity is aware of the suit and is able to defend themselves, then the statute of limitations does not bar the claim against that entity. And notably, as I understand it, the state council represent all of these parties, even the supposedly correct entity. And so the correct entity has been aware of the suit, able to defend from the get-go, and the statute of limitations should not bar the claim against that entity.
But the only thing that gives the trial court jurisdiction to render judgment is pleadings against that entity. And our record doesn't show that there were any pleadings against, I believe it's Scott and White Hospital, DBA, Hillcrest Urology Clinic. And so the question is, did the trial court have jurisdiction over an unalleged claim against that entity, the urology clinic entity?
You know, to be honest, that never occurred to me. I didn't think of that.
I was never able to determine from the record whether or not, I know there were conversations back and forth, you got the wrong defendant. Were there ever any pleadings by way of disclosure, by way of response to request for production or anything else that indicated you got the wrong defendant?
It is my understanding that when they responded, the defendant responded to the request for disclosure, that they put that in there. They did say that. Ms. Vaughn's complaint was, well, I've got no evidence. Give me some actual documents that proves this is the correct defendant. It's my understanding, she never received any such documents.
Are you aware of, I guess this is open-ended law school type question, any way to get a defendant into a lawsuit besides suing them?
No, I guess the defendant, I mean, you could always intervene, but that wouldn't be, that'd be the
If
defendant
you've reviewed the
intervening.
file, have you seen anything that,
I don't remember seeing anything like that, no.
What about any third party claims by one of the other defendants?
Yeah, that would be another way.
Did you see any of that? Our record doesn't show it. That's why we're asking these questions. We just don't see it in the record.
No, I don't remember seeing that either, no. Now, Ms. Vaughn's other complaint was not being able to use the expert, and it's the same expert she used as a Chapter 74 expert, provided Chapter 74 report. Her arguments are, one, under the rule, you can use an expert or designate them late if there's good cause for failing to do so, or if the defendant won't be unfairly surprised or prejudiced. Her argument is that one, there was the failure, the inadvertent failure to calendar was good cause. And two, they won't be surprised because the expert she wanted to designate was the same expert that she used for a Chapter 74 report that the defendant received, and therefore it'd be the same opinions. There would be no surprise.
What about the prejudice prong of that rule? As I understood and I'm going to use generic term, defendant's argument is that the fact that they had already disclosed their expert and provided their expert report, they would then be prejudiced by allowing your expert to be untimely designated, prepare a report after their expert, and thus it would prejudice their defense of the suit.
Well, I would think their expert would be aware of Ms. Vaughn's Chapter 74 report. That would have been taken into consideration in any report. I mean, I'm guessing here, I'm not Ms. Vaughn, but my guess would be, I mean, I would just use the Chapter 74 report as my report. You know, even though there's privilege in these circumstances, I think I would just waive the privilege and just use that report. And Ms. Vaughn's other argument about the expert report is that it's the equivalent of a death penalty sanction. And basically just dismissing the case for not having an expert, and that the court should have at least considered lesser sanctions, and that rather than just dismissing the entire case and depriving this plaintiff of the stay in court, that the court should have imposed lesser sanctions than a dismissal.
Do you have any thoughts about what sanctions the judge should have applied, short of not letting the person testify?
Maybe somehow limiting the discovery, ordering the plaintiff to pay the deposition fees for deposing the expert, things like that.
Do you have any questions?
All right, thank you.
Thank you, counsel. And you don't have to take up all your time. We put a limit on it. So, but you will have 5 minutes for rebuttal. Counsel, you may proceed when ready.
Good morning, Your Honors, and may it please the court. I think I can clear up some of this confusion because, like Ms. Vaughn, who's not here today, I was involved from the beginning of this case.
So tell us how you get a defendant when they're not sued and they don't intervene.
I'm happy to clarify that. When the motion for summary judgment was initially filed, the drafter of the summary judgment, who was one of my associates, and made the mistake of naming the defendant in the summary judgment who had never been joined in the lawsuit, who we had said from the beginning in conversations and in responses to requests for disclosure, you have sued the wrong parties. And this is the party you need to sue. This is the party you need to substitute in, or at least add that party while you're doing your due diligence to determine all the other parties that need to be in. We're letting you know, which is the purpose of responses to requests for disclosures in that particular question. This is the party, this is the correct entity. And that's especially important with an organization like Scott and White, who has far-flung entities.
But their pleadings are very specific as to who they have sued, and they make allegations that would be against a corporate entity, what would traditionally be, because I don't know the organizational structure here, and we hadn't found it in the record, but like a parent subsidiary relationship where the parent could be responsible for the things that go wrong with their subsidiary. And so to say that they are the wrong entity I can see why the plaintiff was skeptical.
And I can see that as well, Your Honor. I certainly can. And so from the beginning, because this happens in almost every case where Scott and White is sued, we as counsel for Scott and White and various of its entities, we always try to make very clear who was the employer, which entity was the employer of the staff who has been accused of negligence. In this case, Mr. Bailey, who is 4 years old, had the cystoscopy at the Hillcrest Urology Clinic. This was not a part of the hospital, but the Hillcrest.
When you say it's not part of the hospital,
That's right.
That's a very vague statement and term.
You mean it's not in the building?
That's
Well-
exactly where I was going. Is it part of the building or part of the corporate structure?
Well, what I think is important here is who employs the people who have been accused of negligence here. That would be the entity who is responsible for the alleged negligence.
But if you let the plaintiff know that, that's your contention,
We did.
and the plaintiff never sues that entity,
That's correct.
okay? And limitations runs, then it's, limitations is run on it, and summary judgment will be appropriate on the grounds of limitations. Your motion for summary judgment says that they failed to designate the testifying expert, and that if you don't have a testifying expert in a medical malpractice case, then summary judgment is appropriate. Then alternatively, you say because they failed to, assert a claim against Scott and White Memorial Hospital, DBA Hillcrest Urology, because the party's never been properly named.
That's correct.
And that the plaintiff's failure to sue the proper entity that employed the staff is grounds for running of limitations and barring all claims as to Hillcrest Urology. And they're not a party to this.
And you're right, Your Honor. And I would like to clear that up. That is the issue here. And I think that if we're going to take up that issue and clear it up first, I think the two cases we need to look at are Chilkowitz and Punn versus Rachel's. But let me first clear up one issue that was brought up. There was a motion for leave to correct the names that was filed, and it was ruled on, Your Honor. I know it's not part of the record. I was not able to find that the order was part of the record, but Judge Meyer did rule on that, and he.
Was it a written order or did he rule on the record,
He ruled
at a hearing?
He ruled at a hearing. And that
Don't
in
you
fact,
think we need that record?
well, Your Honor, I don't think, I think it's kind of a moot point at this, because I don't believe that, I think what you're saying, Justice Johnson, is correct. It wouldn't make a difference in this case, because there was the real party in interest had never been brought in. And I do believe
Then we
that
don't have a real motion for summary judgment.
a traditional motion for summary judgment.
No, we don't have any motion for summary judgment if urology is not in front of us.
That's the only entity that filed the motion for summary judgment.
Well, the entity that filed the motion for summary judgment was corrected. It was corrected and ruled on by the judge.
Did the discovery control plan have a deadline for adding parties?
It did, Your Honor.
And I assume it had already passed by the date of the summary judgment.
Yes, Your Honor.
And so y'all, I guess you could say, attempted to add a party after the discovery control plan foreclosed that.
Correct.
Or was it a motion to amend by the defense to say that the no evidence and traditional motions for summary judgment were being brought by all defendants?
No, it was not. It was just a motion to correct a typo. That's what it was. It was a motion
So what typo were you correcting?
the typo was the parties that were in the lawsuit were the parties that are on the brief. That was who brought the motion for summary judgment. Hillcrest Urology Clinic, Scott and White Clinic, DBA, Hillcrest Urology Clinic.
I'm
had
sorry,
never been
I'm going to
sued.
need you to restate that last. The parties on the brief are the parties that brought the summary judgment.
That's correct, Your Honor. The parties who brought the summary judgment, which was corrected in the summary judgment and ruled on by the court before we could proceed, were Hillcrest Baptist Medical Center, Hillcrest Baptist Medical Center, DBA Scott and White Health, and Scott and White Healthcare.
What, was there a separate brief beyond the defendants, no evidence of traditional motion for summary judgment? I mean, it's a lengthy motion. Was there another, I mean, I think there may have been a response that I saw on the record to the plaintiff's response to your motion for summary judgment by the defense, but I mean, the only way I know of to correct a error in pleading your motion for summary judgment that only urges a motion for summary judgment by an entity that's not included in it would be to ask the trial court to amend the pleading. I mean, maybe it's in the reporter's record,
Right.
but what was that actual transaction like, or what was the ruling, I guess, by the trial court?
So the transaction was like this. We got there, and the week before, we had filed a motion to correct the names. We realized that the incorrect party who had never been joined in the lawsuit was, in fact, the party bringing the motion for summary judgment. And I explained to the court that, Your Honor, this is not a party in the lawsuit. This is the whole point of the summary judgment. It was confusion, and we need to substitute in the names of the parties who are in the lawsuit. And I asked for leave to do that, a motion for leave to correct the names of the parties. The judge, Ms. Vaughn, asked for some time to respond to my motion for leave to correct the parties, probably thinking that I need to look into this. And it affected her, theories of the case. And so we agreed to a 2-week recess. That's what the judge granted. And she never filed anything. So we came back 2 weeks later, and I re-urged my motion for leave to correct the names of the parties so that we could proceed with the parties that had actually been in the lawsuit. The judge granted my motion for leave to correct the parties, and then we proceeded on my no evidence and traditional summary judgments.
Okay, he granted your request for leave. Did he grant your request to correct the names of the parties?
He did, Your Honor.
I mean, all that got.
All of that got worked out. It did, Your Honor. And
But that's all on a record and not in an order that it's signed, right?
that's correct.
And it's in a record that's not part of the appellate record at this point.
That is my understanding, Your Honor. Because when I received the record, it was not on the record.
Okay, our appellate record comes in little chunks, separate capsules, basically.
Mhm.
And so that's something we may potentially need supplemented.
That's right. And
If it's
Judge,
not in there, sorry.
right. And Judge Meyer, it was a rather informal hearing, but I'm confident that because we would not have proceeded, the whole point of the 2-week continuance was for Ms. Vaughn to investigate that and whether or not she wanted to formally respond to my motion for leave to correct the names.
Well, was Ms. Vaughn in both of these hearings as well?
She was.
What was her position at the second hearing?
She had.
Judge Meyer granted your request to move forward.
She had really no response to it, Your Honor, because the whole point of the 2-week recess was for her to respond in writing. And so I don't know if she formally waived it, but we proceeded. He granted our motion for leave to correct the names, and we proceeded.
So let me get this straight then. Judge Meyer's grant of the motion to leave and correct the names included all the other defendants that had been actually sued.
Correct.
But it looks like it left in Scott and White Memorial Hospital and Hillcrest Urology Clinic.
In his order?
Well, I didn't see the order. I just see your motion. And if he granted your motion and granted what you requested, because you say, now comes Scott and White Memorial Hospital, the proper defendant and all other named defendants, and request to correct the names, and you want the names corrected.
I'm just confused about what was being corrected.
Right.
Because if you correct the names, you haven't added the defendant.
That's correct, Your
And
Honor. I
if
mean,
you-
it was essentially a typo that I was correcting is what
Well, this is
happened.
not what I call a typo.
Well, it was,
A typo is, you know.
Spelling Hillcrest on it.
right,
Yeah.
exactly.
Thank you. couldn't-
I understand.
Well,
It was very confusing, and that's why we filed a formal motion for leave and had it ruled on. Because it was, the wrong name was put in there. And the whole point,
So rather than amend the motion for summary judgment,
correct. We
We got
did not
this.
formally amend the motion for summary judgment. We asked that the names be corrected. Because Hillcrest Urology Clinic was not a party to the lawsuit.
So what's the position at this point in time? Is your position that the summary judgment that was granted includes Hillcrest Urology Clinic, Scott and White Memorial Hospital, BBA, Hillcrest Urology Clinic, or just the defendants that were sued?
Just the defendants that were sued. Yes, Your Honor.
and the only defendants in the suit are those that were sued and served by the plaintiff.
That's correct, Your Honor. And, you know, I think getting back to the point of the original no evidence motion for summary judgment, and again, pulling this all together, the point of responses to requests for disclosure is to correct those names. And even if there's confusion, and there will be confusion whenever Scott and White is sued because of its breadth, the plaintiff, and I think this is clearly laid out in both the Vanscott case, the Chilkowitz case, the plaintiff has an obligation to add those parties. In fact, Chilkowitz, the court actually said, you know, we're going to let you, because this was a true DBA situation in the Chilkowitz case, and the court said, well, you know, we're going to let you maintain this suit, even though, you know, because this is a true DBA, but you need to add the party, formally add the party that you've been told is the correct party. At that point, had Ms. Vaughn, in response to our informing her of the correct party, even if she didn't trust us, even if she wanted to do due diligence with regard to the other entities, she had an obligation to add the correct entity.
Only if she wanted a recovery from that entity.
Correct. If she wanted a recovery from that entity, which we're representing, was the employer of the people that she's suing.
But I get back to my other question about they have the choice of who they're going to sue.
Correct.
And they chose apparently to sue the parent or some affiliate that may have managerial responsibility for the subsidiary. And so there still exists the cause of action by that entity. And I'm struggling to see if it's a healthcare liability claim or not, as opposed to some other type of negligence claim. And that kind of runs headlong into their pleadings, but they do have another entity that they can sue. They're not limited to just the employer.
Absolutely, Your Honor, absolutely. But in this case, and I really do think this is, you know, in the scheme of things is going to end up to be a moot point. Let's say that she's entitled to sue all of those entities, and she's entitled to, you know, try to prove that they're affiliated. She's entitled to go through all of that process. I'm not saying that for a second. Then let's get back to the no evidence summary judgment. She brought this case as a healthcare liability claim. She brought it as a discovery and control level 3, which means it anticipates a discovery control order. She issued and served a request for disclosure, and she at arm's length negotiated that order for a docket control order. Under the rules, she is obligated to honor the docket control order regardless of the defendants. And she has the opportunity to do her due diligence. She has the opportunity to do any sort of discovery she would like to do, to determine, including depositions, 202 depositions. I mean, any discovery she wants to try to do her due diligence. But getting back to the no evidence summary judgment, if you bring a claim as a healthcare liability claim, which she did, she has to have expert testimony, regardless of who she's bringing the claim against. And the pleadings, which we have to rely on, are her pleadings. So Ms. Vaughn brought the case in against these entities as a healthcare liability claim. And these entities answered the lawsuit, were in the lawsuit. The entities and Ms. Vaughn engaged in negotiation to set a docket control order. They did. When Ms. Vaughn failed to meet her discovery to name an expert witness at her deadline, a month later, the defendants named their experts. Ms. Vaughn waited for 17 weeks after the deadline that she needed to name the experts. And at that point, asked the court to grant her leave for good cause and arguing that the defendants would not be prejudiced. And the case law is very clear. And from this court, in fact, a couple of cases, the Agristar case in particular, the inadvertence of counsel is not an excuse. An inadvertence of counsel under Rule 193.6 does not constitute good cause. And that comes out of this court, it comes out of the Supreme Court a number of times, it comes out of many, many courts. And so then the question, if she can't convince the judge that she had good cause for failing to meet the deadline, her other option is that the defendants would not be prejudiced. The Texas Civil Practice and Remedies Code is very clear in Chapter 74.351 that a Chapter 74 expert report, a threshold expert report, cannot be used in any context. It cannot be relied on in depositions. It cannot be relied on in any hearing. So that automatically sets up the prejudice. The defendants should not have to anticipate a rebuttal witness. And having done this for 30 years, I can tell you that very often the Chapter 74 report is different from the eventual testifying expert. The cases change, they evolve, and that's why I think the case law has been very clear that, especially in the Columbia case, the Cunningham versus Columbia case, which is exactly like this one, that just urging the court to rely, or just urging the opposing party to rely on the Chapter 74 report is improper in terms of prejudice. With regard to the no evidence summary judgment, the parties that did not appear, the case would be the same with regard to those parties. She was required, had she joined these parties, she was required to designate an expert.
But you're telling us these urology is not a part, period, top side and the bottom.
Urology is not a party. Urology has never been
Never has
joined as a
been,
party.
never will be.
That's correct, Your Honor. And so I think that, I think it's pretty clear with regard to the no evidence summary judgment.
So why do we have to worry about
Why do we have to worry about?
statute of limitations at all?
I don't think you do, because I think it's a jurisdictional issue. I think that the Pun versus Rachel's case and the Bailey versus Vanscott case are the cases that should govern the traditional
I mean,
summary
if
judgment.
they go sue urology now, then we'll talk about Vance and
Exactly.
those cases. But if your contention is that the party that filed the motion for summary judgment is not a party in this suit, that's
My contention, Your Honor, is the party that filed the summary judgment is the party in the suit.
And that's because of your motion for leave.
And that's for my motion to leave that was granted by Judge Meyer.
One question.
Yes, Your Honor.
Okay, your motion for leave says that you now move for leave to correct the named defendants to include defendants Hillcrest Baptist Medical Center, Hillcrest Baptist Medical Center, DBA, Baylor Scott and White, and Scott and White Healthcare. It doesn't say and exclude the urology group. And if the judge granted your motion, again, down in your prayer, It's the same request to include those defendants. But you didn't take out this other entity that we've all may agree at this point in time has not been sued.
That's
So,
right, Your Honor.
so do you, I mean, at this point in time, do you concede that the summary judgment your clients prevailed on did not include a summary judgment in favor of, let's see,
Scott and White Clinic, DBA, Hillcrest Urology Clinic. Absolutely.
Okay.
Absolutely. The court never had jurisdiction. So in that regard, the traditional summary judgment, rather than being an actual, and in all candor, I didn't expect the judge to even take up the traditional summary judgment. And when he granted, because it wasn't discussed at all. And when he granted both the no evidence and traditional summary judgment, that surprised me. I don't think that's correct, because I don't think, based on the way the arguments went and after the motion for leave was, I don't think that was a proper case.
In other words, you're waiving any reliance upon the traditional motion for summary judgment at this point.
Yes,
You're
Your Honor.
relying solely on your no evidence motion for summary.
Yes, Your Honor. And my no evidence summary judgment as to Hillcrest Baptist Medical Center, Hillcrest Baptist Medical Center, DBA, Baylor Scott and White Health, and Scott and White Healthcare.
Okay, thank you, counsel. Well, we've discovered some things since you left the podium.
Yes, Your Honor.
So how would you like to respond?
Well, to be honest, a lot of that was Miss Vaughn, and she wasn't there, and a lot of it I just can't respond to. I've listened very carefully. And, to be honest, I don't think there's anything more for me to say. I can try to answer questions if you have.
Okay, thank you, counsel. This case is submitted and y'all are excused. And if there is any supplemental briefing, normally it's only of cases that are cited during oral argument that is not already in your brief. But if in light of the arguments that were made, if there is additional briefing that y'all feel is necessary or appropriate, traditionally it's been Friday is deadline to get it in. That's 2 days from now. Unless you get a letter from us, that's what it'll be. And we'll let you know if we need additional supplemental briefing beyond what y'all may provide by Friday. Okay. Thank y'all, and y'all are excused.
Thank you.